subscriber and member. He offered me a coffee and took some free advice. Okay, so and he didn't want to come live on the channel. That is fine. So I think he works over here. So it's Goswell Road. I'm still in central London. Let me just maneuver my way to the station, and I will answer any questions. Hassan Hafiz, thank you very much for becoming a member. If you have any questions, please ask me. Okay. Okay, now I am live, and this is an open live for everyone, but I think there is some timing, 20 minutes or so for new subscribers. Anyone who is already a subscriber can ask me any questions. Come live, ask me any questions that you want to. Hassan Hafiz, a new member. Thank you for supporting the channel. Most of that money, almost all of that goes into donations and all. But yeah, do support the channel. It's some nominal fees of £2 or £3. Yeah. So, and is my mic working? Hello, hello. Yeah. So I was talking about e-visas, etc. in the previous live. I've started this live again, uh, touching on these e-visa points. The some other member did ask whether 6135, the care workers code. I did check it while I was at the OCI, Indian OCI office. By the way, my job is done, so OCI is applied successfully. Yay. And this is the second time I came here, and finally I was able to get it done. So about 6135, somebody asked in the previous live, which I was live about 41 hours before I was live, and 6135 job code, you cannot bring a dependent. So 6135, 6136 were the previous job codes. Yeah, and now I think they've become 6145 and 46. That's the only difference. So on 6135, if you are on 6135, you cannot sponsor a dependent on that. So remember that. Other things that I wanted to talk, FLRM applications. Home Office has started refusing FLRM applications which have been just filed to buy time. So anyone who's filed FLRM applications to buy time, please be mindful of that. So yeah, and yeah, this, thank you very much to the member who just offered me this coffee. I was walking in central London, and yeah, I was coming from the OCI office. He met me. He asked me some questions. He didn't want to be on the live, so I stopped the live and I restarted it, and he offered me a coffee, answered some questions. I don't do that usually, but yeah, I see that I have been bumping onto members and subscribers now. So anyways, yeah, if you meet me, maybe I can give you 2 minutes of my time and answer any brief questions if you find me anywhere. Now I am walking in central London towards Farringdon station. Okay, so what was I talking about? FLR applications. So the further leave applications that individuals are filing, students, skilled worker holders, graduate holders who don't have any basis, any other basis of staying in the UK just to buy time, be careful of that. I think recently individuals who have filed themselves these applications around, I've seen some refusals. Once the refusal comes, usually they do consult with us, but then they have filed the FLRMs themselves or through some other lawyers, something, just to buy time. And what I've seen from these refusals is current timelines that I saw, things that were filed around March, April this year have started coming around October, November. So around 6-7 months or so, decisions have started to come through. I'll cross the road. I'm crossing the road now, and so that is what is happening. 6 to 7 months is the current decision making that we have observed. It may also come, it may also get much faster, I would say, the processing. I think they will somewhere come back to 3-4 months processing also, because Home Office has got to grips with this FLR applications that are filed to buy time, and they have started refusing them. One very important point for FLR refusals, they are putting everyone whose FLRs are refused on immigration bail from the date of decision. So if your application is refused today, then you are put on immigration bail immediately from today. And the problem with immigration bail is you cannot switch to any other visa category from within UK. For example, you are a student or graduate holder, and if you are put on immigration bail, uh, let's say today you get the refusal and the letter says you are on immigration bail from today. At that point, you are basically unable to switch into any other visa category. You have to go back to your home country if you are filing any other UK visa application. You cannot switch from within UK. So that is the problem with immigration bails. So the buying time basically doesn't ends up with quite a messy result, and what you were trying to do. So if you filed FLRs, I always advise against filing them. Just don't file them. If you have a reasonable case, let's say you are planning to apply for graduate route, your results are delayed, or you are having a resit, or let's say you are applying a skilled worker visa, but your sponsor doesn't have, you have an employer, but they are trying to get the license or the costs or something, then file pending applications and get it through, file it through lawyers. We've done many of such applications, pending results, receipts for graduate route, pending cost, pending sponsor license application, etc., etc. So that is something that you should definitely consider in case of rather than filing these intermediate applications. That's what Home Office also doesn't like an FLR or that fee waiver also. Yeah, I've heard bad stories about those fee waiver ones. So I don't recommend fee waiver applications or FLR applications just to buy time. If you have a genuine case, then you should file that application pending whatever it is. And one of the important considerations that I wanted to explain is students, they will qualify for 4 year, up to 2 years after they leave the UK. Let's say this is also one of the options that you should always consider, is leaving the UK and applying for the jobs from your home country. Because I know I've done many applications where individuals were students or graduate route holders. They still get the new entrant discount for up to 2 years after their visa has expired. So if a graduate route holder leaves the UK, let's say 31st of December was their permission end date on the graduate route. From 31st December for up to next 2 years, that is 2024, was their student graduate route expiry date. At 2 years, 31st December 2026, up till that time, they can make an entry clearance application as a new entrant. So they will have the new entrant benefit even from outside UK. So this is also my wise advice, that if you don't have any options, you may consider going back, applying for jobs and all, whatever you want to do from your home country. I know no one listens to this advice, but this is a good advice that does work out. It has worked out in many cases. I know that almost 90% people don't take it whenever I tell them, but that is one of the options that you should always consider if you don't have any options, and just don't file these frivolous applications to buy time, work in the UK, live in the UK, FLRs, fee waivers, whatever they are. So either pending applications, if you are going to get something, a course, a pending result or whatever, failed receipt for graduate route, pending costs, pending sponsor license application, etc. Do pending applications, use lawyers and all. We do provide advice, we represent applicants. We only provide free advice during these lives. All other advice is always paid. So we charge for our advice. You can book a paid consultation with us. And so either pending applications, pending anything. And the second option is thinking of going back to your home country and then applying as a new entrant. If you were a student, you will have the new entrant benefit for up to next 2 years to apply. And also for a graduate route, for up to next years, you will have the new entrant benefit that you can apply as a new entrant. Yeah, because we've done many such applications where people have left the UK and then applied from outside UK once they were able to sort out the costs, etc. Okay, I have a live question. Hear me. What does this mean for graduate route student visa holder? I will cross the road and then answer. Okay. What does this mean for a graduate route student, graduate student visa holder applying for dependent now? Do you have permission to stay What does this mean for a graduate student visa? Graduate student visa holder applying for dependent, yeah, permission. Yeah, if you're applying for the first time, then the answer to that question should be a no, because you don't have any permission. You have permission to stay as a partner of that main applicant. So if you are applying for the first time as a dependent, then the answer to that one should be a no. But I cannot answer application questions on this live. For that, please book a paid consultation. But yeah, just to help you out, that answer would be a no if you're applying as a dependent for the first time, whether outside UK or inside UK. Because for the home office purposes, you were never a dependent of that person. So that is what that question is asking you. And if you're already a dependent partner, then the answer would be yes. Okay, so what was I talking? FLRs and fee waivers summarily don't file unless there is a genuine case. I know there are less than 5% cases who are really genuine on those FLRs. So 95% cases that I come across, I have heard of. Home Office is taking a very hard stance on this, and they are refusing this and putting people on immigration bails. That is a summary of what the topic that I was discussing. While I came in the morning, I discussed in my previous live about e-visas, issues around e-visas, etc. So watch that live if you want to learn about e-visa problems, how to solve them, etc., etc. And now I'm coming to the train station. I discussed about FLR applications mainly, where we are seeing refusals and people are put on immigration bails. So common occurring, yeah, everyone is getting those. So this is the latest thing that is happening. Don't file these FLR applications yourself with lawyer, whoever is telling you, just to buy time. The lawyers will make all the money, you will lose your money. Don't waste it. I understand that you want to make a career in this country, but you end up with such weird situations and frauds, and so be mindful of that. Next question, MK, how many time take first tribunal appeal nowadays? Nowadays, I think approximately at least a 1 year waiting period is there for most of the appeals, minimum 1 year and going. So FTT, if you're going with the first tribunal, yeah, we have some appeals filed. Some of the appeals are withdrawn by Home Office at the respondents review stage around 6 months or so, 6 months, 6 to 8 months, yeah. Because these first year tribunals are quite clogged with these EUSS appeals. Most of these EUSS, EU settlement scheme applications get refused. Uh, Thank you very much, Yemi. Yeah, subscribe to the channel, become a member, support the channel. Yeah, okay, so First Year Tribunal is quite clogged. There are a lot of applications. I know we have many applications that are filed. Some applications do get decided at the respondents review stage, uh, but then that still takes about minimum 6 months to a year, 6 months or so. And minimum waiting time for First Year Tribunal currently about 1 year or so, at least 1 year. It's more than that slightly. Thank you very much, MK. Thank you. Okay, so and I have some time till I go into this Farringdon station. So yeah, one of the channel subscribers and members he just met, we bumped in central London. He was watching my live and he showed me his phone. He was watching me on his phone, and then yeah, he did offer me a coffee and he asked some questions. So yeah, if you do bump into me anywhere, say hi and you can ask me any questions. But yeah, usually you may not find me outside much. So yes, and I will go into the train station now. Which way to go? If you have any questions, anyone coming live can ask. I'm going to go into the Farringdon station. This live may, so you will see a loading page, but I will join this live as soon as my train comes out of tunnel. So approximately about 10 minutes or 15 minutes on a higher end, 10 minutes I think, I'll be back in outside the tunnel and this live will again open up. So I'm not going to close it, but if you see that round circle reloading page going on, uh, but I will still take some questions maybe for 5 minutes. I think my internet is fine over here. So what do I do? Okay. Okay, let's go. Okay, yeah, if you have any questions, do ask me here. Not bound to Bedford. Yeah, platform 4. Okay, I'm trying to find. Yeah, I think there is still internet now, so anyone coming live can ask me questions. I'll be live as much as possible till the internet goes off. Okay, I was talking of the FLR applications. Yeah, think my train will come. Let's see, it's still working. My life. So, okay, where do I have to go? Maybe should go to Bedford. Yeah, I think my internet is still on. I'll try and wait over here and see how it works. Train. Nearly Broadway. Okay. 5 minutes, Luton. Okay, my train is coming in 5 minutes. I will use that time to answer any questions. Yes, I was talking of, okay, no more live questions, so I will talk on some general topics. I did, hello, yeah. So if there's any disturbance in the line, there may be some, but yeah. So FLR applications, don't file them unless you basically don't file them. They are very rarely, they should only be filed if you have a genuine case. For example, you are sick, cannot leave the UK for whatever reason. You cannot physically sit on a plane and leave the UK. I have done in the past many cases we've done where someone is pregnant, cannot travel, they came on a visitor visa, something like that, or their visa expired. And they are unable to travel. Sometimes elderly dependents, they have arthritis issues or something increased. Doctor has advised. So you need a doctor's letter or third party letter to confirm if you want to get any FLRs, and it has to be a genuine thing. Doctors don't just write letters for no reason. So other than that, filing FLRs just to buy time is not recommended. Home Office has been refusing them, putting people on immigration bail. Be mindful of this. I'm warning this in most of my lives and my videos, yeah, because this is happening and it will just ruin your situations. You won't, once you are on immigration bail, you cannot switch on to any other visa from inside the UK. So kind of you are an overstayer. So as soon as you are put on an immigration bail, you should leave the UK as soon as possible, usually within 28 days from the point you are put on immigration bail. So that is my advice to everyone. And what else? Okay, let the train go and I will talk something. Fee waiver. So I am at Farringdon station and the train is leaving. So I have about 3 minutes for my train to arrive. Anyone joining live can ask me any questions. I also have a personal. Okay, I will talk about that thing also. Okay, the train is gone. No more live questions. So, yeah, I talked about the max consultation going on for the financial requirement for the 5-year route. Google search for max consultation and fill up that consultation and give your opinion. They are working on seeing whether the 29,000 financial requirement is working or not, or they need to make some changes. Do that. If you'll ask this one, about EU settlement scheme also. If you have a certificate of application and you're trying to come to the UK, you're traveling in the UK, you may not be allowed unless you have a proper status. Let's say you have filed EU settlement scheme application or it's pending decision, or you file it is refused and you filed an appeal. So the only thing you have is a certificate of application. In the past, you were allowed to go in and out. Even legally, yes, you are allowed to go in and out, but the border force guidelines have changed. Immigration officers have a right to assess whether you are eligible under the EUSS or not, and decide whether they want to allow you in the UK or not. So this is a new change that has happened. People are being stopped at the border and questions are being asked. They will assess your eligibility, whether you have a genuine eligible case or not, under that you assess to get pre-settled status or settled status, whatever you are claiming. So they are going to try to become a first tier tribunal judge or a caseworker and try to assess your case at the border. If you just have a certificate of application and you don't have any status under the scheme. So yeah, that certificate of application will tell you you can travel in and out of the UK. Yes, you can, but when you come to the border, you may be assessed by the immigration officer. And I know of many, many cases where they have refused entry to people. Okay, another train. EU. Okay, MK is asking EU appeal success rate. It depends on the facts of your case. So if you have a genuine case under the USS, yes, it is possible. But then usually if you are just trying to file as a family member, I see many visa nationals, they just file on the basis of some uncle, auntie, or some relative in the UK who has some USS status or a EU national. Those applications not going to go through. I know people challenge. Someone also asked on the channel, I think, in some questions, where he came as a student, came to the UK, then tried to apply because his uncle was an EU national living in the UK, and they refused him several times. Yes, those cases are not going to go through. He will never get any status under that. That is not a basis. Just having a relative does not help you. There are other eligibility criteria. You should be dependent, financial dependency, or whatever dependency you have. So all those things come into play. So USS appeal success rate, it depends on the facts of your case. You should speak to an immigration lawyer and deal with it. So So my train has arrived. I will get in. I think the internet will stop, but I will keep this live open. It will open as soon as it comes out of the tunnel in about 7-8 minutes, I think so. And I have to run now because this train is gone. I'm still live. Just okay, my internet is still on. Okay, this live will just reload again and again, and it will start shortly after. The OCI office. Am I live? Yeah. At the OCI office, and yes, you dependents are not allowed on 6135. So 6135, 6136, or 614, 6145, and 6146. So previously it was 4546 under the SOC 2020, 2010. Under the SOC 2010, it was 6145 and 46. Not allowed on 6 month. Yeah, if you watch the previous section of the live, I've talked at length about it. And e-visa issues, which I discussed in my early this morning's live. I will try and answer some questions that I have seen on the channel. So just to, I will discuss the appeal stages. I think there were several questions on appeals. So the different stages. Okay, so the different stages of an appeal are, usually if you file an appeal, Okay.
Good afternoon. Sorry to bother you down, everyone. I'm Jason. I'm harmless.
Okay, so I wanted to discuss the stages of appeal. These are the common questions I get. There are many people. There are very less types of applications which are eligible for appeals now. One is human rights applications, spouse visa, child visa, parent visa, some of those. And the EU settlement scheme, the whole scheme, any application under scheme is eligible for appeals. So the way the appeal stages work is you file the appeal. I think there were some questions on appeal, so I'll just run through the steps in an appeals, what happens with the first tier tribunal. So as soon as you get the refusal, if you are inside the UK, you get 14 days to appeal an application, 14 days, within 14 days. And if you are outside the UK, you get 28 days to file an appeal of the application if you are given an appeal right. Usually it should be a human rights application or EU settlement scheme application. So remember that. So other applications don't have appeals. I'll just briefly touch on admin reviews. Any points-based applications like skilled worker applications, graduate route, student visa, any of those refusals, they only get an admin review. What is the meaning of admin review? It doesn't go to any third party for any decision. Some other caseworker looks at it. So, for example, if I'm a caseworker, I have looked at your first case, first application for a student visa or a skilled worker visa. I refused it, and if you file an admin review, my colleague over Mr. X will look at it and he will consider the case if I have done any mistake in making a decision. And that's why the success rate of admin reviews is very low. Admin reviews are mainly for any administrative errors. For example, you submitted a bank statement, but oh, I forgot to look at it and I refused your application, something like that. Some error that could have been avoided, and the person just did a mistake and they refused it. That is where those are the only points which would ideally be successful. New evidence is to a greater extent not allowed. You can't just add on evidence and say, oh, I didn't submit this, but I am adding on, because the only way they are looking at the application which was refused. How was it? Did I do any mistake? If I was the first caseworker, the another caseworker who looks at it, he will only look at the same evidence, same application, same everything. So new evidence addition is not allowed. So that is all about admin reviews. Admin reviews are currently about 12 months and waiting, 1 year and more. All ARs are taking. There, so admin reviews under the PBS or any, the queue is the same for everyone. Under the EU settlement scheme, there were admin reviews which were allowed till last August, I think, last year August. Yeah, last year August. And after that, the admin reviews were not allowed. Directly, you have to appeal. So, because of the EUSS previous admin reviews, they are still in the queue. I know of many. The queue of the admin reviews is very high. That's why if you file an admin review, sometimes it is better to make a re-application in case of any points-based applications such as skilled worker, student visa, graduate route, global talent, or whatever. So it is better to file a new application and get it sorted rather to wait for a whole 1 year or so to get it sorted. So that is about admin reviews. About the appeals, if you have been given an appeal right in your refusal, yeah, so I will get into the appeal side of things. If you have been given an appeal right inside UK, you have 14 days from the date of decision to make an appeal. Outside UK, you have 28 days to make an appeal from the date of decision. Firstly, okay, you fill up the online appeal form, you submit it, it goes to the tribunal. Yeah. We will be calling at Mill Hill Broadway, Elstree and Boreham Wood, Radlett, St Albans City, Harpenden, Luton Airport Parkway, and Luton. Okay, so appeals, first you file the online appeal form, submit it, make the fees payment. Usually £80 is the paper appeal hearing. We don't recommend that unless it's a very straightforward case. But usually whenever lawyers file it, they would always go with a barrister or something, have an oral hearing. Oral hearing fees is £140 is for the appeal, and that is for the appeal at the first tier, and that continues. So 140 is the appeal hearing for oral hearing, and £80 is the paper hearing. Paper hearing very rarely you should file, unless it is a very straightforward case where the judge will look at the documents and say, yes, I am approving it. Okay, so okay, Babakar, success rate, parent visa in the UK. Success rate depends on the facts of your case, Babakar. If you have a genuine relationship with the child, you are engaged, you are involved in the life of the child, you have some evidence. I think last time you did state the evidence that you have some letter from GP or something. Those evidences are reasonable. With such evidences and the relationship being genuine and support from the other parent, if you get an affidavit, there is a format on our website, you will see parent visa in relationship without out of like not related, or whether you are in a relationship or not. There are two different affidavits. You use that format, customize it and use it. It's almost, we've always got it, so it's 100% for us if you have all the evidence. That's what I would say. um, they are not going to refuse the application. Yeah, home office doesn't do that. If you have given them all the evidence and you have eligibility and everything is genuine, relationship is genuine, your uh, your uh, your engagement in the life of the child is genuine, that's fine, they will approve it. I've never had any backfiring. They ask for some additional information and all, but that's it, not much. Yes, Babakar, thank you very much. Yeah, you can contact us. That is fine, and it should be fine. Secondly, yeah, I was get talking of appeals. Sorry, I got distracted. We file the online appeal, pay the 140 pounds of oral hearing or 80 pounds of paper hearing fees. After that, it goes in the tribunal's case list, and the tribunal sends that appeal to the other side, to the home office. Home office basically confirms they also want to continue with the appeal at that stage. And then the tribunal gives you some days, I think at least 1 month you have to arrange the appeal documents, minimum 1 month or slightly more. The tribunal tells you a deadline to upload your documents and evidence, whatever you are challenging. Then, and nowadays tribunals, the new practice direction has come into play with the appeals. I was on the Immigration Lawyers Association meeting, and I think we asked some questions to the judge also, what is expected in the skeleton argument, and also they did clarify. So what is expected is, at the upfront, a skeleton argument is also requested by the tribunal that we see, and that skeleton argument, I'll summarize what that is. So I do appeals and also, yeah. So with all the documents, whatever your skeleton argument you need to prepare, upload it, that is sent to the other side, to the home office. They look at it, that is called as respondent's review. So the home office is the respondent, you are the appellant, and they look at all the evidence, information, and they decide whether they want to continue or not. My station is coming, so I have to get down. Yeah, so so they will decide whether they want to continue or not. After that, if they decide, they can withdraw the decision. This has happened to several appeals that we filed. We do it exhaustively. I will get down and talk about this, just 1 minute. Okay, I think my station is coming. Yeah, so at the respondent's review stage, all the evidence will be reviewed by home office. Sometimes it is not a meaningful review. That is the other challenge that we are having with home office. Sometimes they don't look at the evidence and they just continue with the appeal. So that is another thing that we are trying to sort out with home office, to do a meaningful review, which means they should sensibly look at what has been submitted and withdraw or decide to continue. So that is one point. If they decide to withdraw, they will issue the visa and continue, or reconsider, and also refuse it on more grounds if they want to refuse the decision. So that is about respondents review stage. Yeah, just a minute. I'll just pick my bag. Yeah, so that is the stage of respondents review, where you have given your skeleton argument. So what is that you are going to argue on, and give all the evidence. It goes to the other side. Home office checks, they decide, oh, we made a mistake, we are happy with it. Yeah, that happened to several appeals that we filed. Too much noise. Okay. And they withdraw the decision, issue the visa, or they withdraw the decision and issue another refusal, whatever the problem they have, something like that. That's, but another refusal is quite rare. So I will go down and explain further. Okay. Okay, I'm back. So I'll take the live question in just 1 minute. I have to complete my appeal story. So after that, if they decide to continue, then Home Office files their side. Everything goes and sits in the tribunal with the legal officer at the tribunal. They put it on the list of hearings, and then a hearing date is given, and you go for the oral hearing where both sides argue, barrister goes, and that's how an appeal is decided. So these are all the stages: filing the appeal online, then submitting your evidence, Home Office checking and deciding whether they want to continue, then they file their evidence, and then it goes for the hearing. So these are all the stages. I'll just take live questions. My husband is a holder of 6135 work previously held January 23. Okay, I got the facts, the broker, but what is your question? Okay, I understood all the facts. I'll take the next question. Ask me what your question is. Okay, so Garasenvi, can I use my SEMA UK accountancy exam qualification as proof of my English competency? No, I don't think so. I'm not sure. But you have to speak to UK Actis, ask them. You can just call the Actis, they are helpful. It is a business for them, so they have to sell the Actis service to you. You can call them, send them without charges, they confirm. Usually they do, I know. You have to tell them this is the degree I have, and they don't charge you unless they are confirming that they will issue the equivalency. So if they are happy to issue, then pay them, get the equivalency. But I really doubt whether SEMA UK accountancy will be, I don't know whether it is considered as a degree or not, but to the best of my knowledge, I don't think so. So I'm waiting to cross the road. But yeah, check with the Actis body. You can call their customer service, email them. You can also send them your documents. I think they look at it and they will confirm, yes, we can issue, then you can pay them or something like that. They are flexible. It's a business for them. So that is the first part. So the question is, how can wife stay back as 6135 won't be his dependent? She applies for entry clearance from outside. Entry clearance from outside. Yeah, I really doubt whether an entry clearance would be granted. If it was in the UK, you may have filed something on human rights basis. But if your partner is outside the UK and trying to join you on the 6135, the rules don't allow any exception. I doubt whether it will be approved. I'm sorry, but that is, I have to tell you what is in the immigration rules. There is no basis. I understand that there is some health condition about the child and all, but I don't think on a PBS application those things are considered. Those are outside the rules. So it is quite highly unlikely that the partner can join you on the 6135 job code that the main applicant is on. So next question. Okay, I haven't got any question yet. So what was I talking about? Yes, FLRs I've done. Appeals, yes, appeal waiting period. All the appeals come in the same bucket, whether it is EU settlement scheme appeal or human rights appeal, at least 1 year and going. Respondents review stage where Home Office takes back their decision. They don't take it every time. Yeah, so make sure you use proper lawyers and legal representations. I've had some decision withdrawals last year under the USS and human rights also, family, spouse and all whatever. But then usually they wouldn't withdraw. If they withdraw, that takes about 6 months minimum, I think so, from the date of decision. There are different stages, appeals and all. I will cross the road now. Okay. Yes, you can contact me for the human rights application, but with Home Office, remember, I don't want to give you wrong hopes. I don't work like other lawyers, so other lawyers may just take your money and file whatever nonsense, but we don't work like that. I don't work like that. So there is whatever information you've given me, that is quite a less chance of success. I would say 20 to 20% chances of success. So depending on the whatever facts I know, I understand you are trying to ask an exception under a PBS category. very less chances of success, even 10% or less. So I understand you may book a paid consultation, but don't expect much. I have to tell you from whatever facts you have told me. So I'm not promising anything. It is less than 10% chances of success. Home Office doesn't give up on, from whatever past experience I have seen, they don't exercise much discretion on PBS based applications where family members are trying to attach themselves to PBS applications. This is a common occurrence that usually every lawyer knows this. So I have a low battery warning. Yeah, you can book a paid consultation. We don't give any free advice. So any contact with me directly for a video call, audio call, whatever you want, it is through paid consultation. All the links are in the channel information. I will cross the road now. 1 minute. Ooh. Okay. So I have 20% battery remaining. So yeah, we do provide advice and representation on any UK immigration matters. We charge for our consultation. We don't give any free advice. Okay. Only during these live sessions the advice is free. Whatever I'm talking here. Rest. So I've talked about FLRs, I've talked about e-visas. These are all common things that are happening now, questions that I'm getting, Home Office updates. EU settlement scheme, very, very important update that is happening that I did start talking before. If you have a certificate of application, you are allowed to enter and leave the UK. That is still the case. But the immigration officers are assessing at the border. Let's say you don't have any status in the UK under the EU scheme, EU settlement scheme. You have filed an application that is pending and you don't have any status yet. Its decision is pending or appeal is pending. Home Office immigration officers, the entry clearance guidance has been amended for immigration officers. So they have a right to ask you questions, assess your eligibility under the EU settlement scheme, and only then they would allow you to enter the UK. It is quite important, and many EU national and many individuals in such cases, they have been refused entry. It is a common occurrence now. So this is the latest thing that is happening on the EU settlement scheme side. You have a certificate of application only and no status, which means you have a pending application, pending appeal, anything pending. And immigration officer, you should always carry all the evidence of your residence in the UK, your relationship, if you are a family member, dependency, whatever. Basically, your application will be assessed by the immigration officer technically. If your appeal is pending, the immigration officer will become an appeal judge and try to assess your case over there and decide whether you have a genuine case, whether you are really eligible under the scheme or not. Only then they would allow you to enter the UK or they will refuse entry. Yeah, I know of people who have been refused. Yeah, so from other lawyers also, from inquiries. Yeah. Okay, and the live question: I have been made permanent in my current role as a civil servant, arm's length body, Department of Health. Will I still be required to prove my English for my worker visa? Yes, you have to prove your English if you are applying for a skilled worker visa. Doesn't matter what your job role is. Even a CEO of the company has to, yeah, so they have to prove their English language if they are from one of those English countries, what we call them, list of English language required countries, whether you have it through either education, equivalent UK degree, or outside UK degree, you need the ACTIS letter or you give an English test. Yeah, English language requirement for the skill visa is required. Doesn't matter the type of job that you said. Doesn't matter. The job role is irrelevant. It's the visa's requirement. So yeah, everyone is required to give this English language test. Yeah, even I had to give my English language test just on the sideline when I had to apply for my indefinite leave to remain. Now I'm a British citizen. Yeah, at that time I have a double graduate degree. I have a law degree. I have an accounting degree, bachelor's in accounting. I have a bachelor's in law. I have many other qualifications also. But still, because it is not from the UK, I had to give an English language, and it's very easy. It took 10 minutes for me to give that ILR English language test. Okay. So yeah, everyone, even lawyers have to take it if you don't have a UK qualification. I don't have to study in the UK. I have studied in other countries, so that is fine. So English language requirement is required. What else? Okay, this is the school. Checking if I can see my kids here. No. Okay. Anyone coming live can ask me questions. I have about 10-15 minutes more walk to home. Then I have to eat and have a consultation quickly, immediately at 2. Okay. But my OCI work is done. Thank you to the VFS office in Goswell Road, Indian VFS office, Indian visa office. Yeah, last week I did go there, but I was not able to get through. They asked for many other documents. That is common with Indian offices in India. We are used to that. So nothing against them. And thank you that it was done completely today. So I usually go live once in a week. I think next week's live I will schedule it for Monday. Yeah, I will reschedule it. I think I am using that live over here now. So, and if you do like this live, subscribe to the channel, become a paid member. There is subscription option just for £2. I think £2 or £3, whatever that is. Most of the money goes in donation. Almost all of it goes in donations and all. So yeah, that's just to encourage YouTube. Yeah, to encourage showing our videos and all. Okay, so what else? I've made some other videos that I will release. I talked about FLRM applications. I talked FLR applications. I talked about e-visas. I talked about appeals. Anything anyone can think of can give me any suggestions. I have some time. Why not use it? Okay. And yes, do subscribe to my personal channel. That is very, very important. So there is another channel. You will see it. I'm going to make some videos on the. Yeah, there are some legal explanations, legal language with life lessons and all of that. So do subscribe to that channel. So that will be more my personal side out of immigration rules. It will be mainly my other interests, mainly a real lawyer deciphering some other things other than immigration rules. So yes, that is something that I'm going to start on my personal channel, maybe within a week or so. So do subscribe to my other channel, Simply Sachin. That's the channel. The link should be there in the channel information or in many of my video cards. And what should I talk? Other things, skilled worker, student visas. Student visa financial requirement is changing. I think I've already made the video from January. Yeah, 5th January or 2nd January. Yeah, it is in the video I have stated. So, and you need, if you are applying for a student visa, your course period is more than 9 months, you need at least 9 months of maintenance requirement. So whatever that is, 1423 or whatever, you multiply it by 9, and that's the maintenance requirement. You hold it at least for 28 days in a bank account, and the last date of that bank account statement should be within 31 calendar days of the date of application. Yeah, very good. I did say that. Okay, was regarding working additional hours under skilled worker visa. Additional hours under skilled worker visa, supplementary employment. Once you are on a skilled worker visa in the UK, you can work up to 20 hours additional in any skilled job. So remember, you have to search on the website gov.uk skilled occupations. So those are the jobs. You can only do those jobs. You cannot just go and work in a retail sector or somewhere, or yeah, anywhere, or a delivery person or something like that. You have to be in one of those skilled jobs. Skilled jobs are the jobs on the UKVI website which are sponsorable for a skilled worker visa. So you can do up to 20 hours a week on top of your normal job in any skilled occupation. That is the law with supplementary employment. That should also show up on your right to work. You are allowed up to 20 hours maximum per week in supplementary employment in any other skilled occupation. The skilled occupation part is very much important. People always confused with that, and I know people are trying to work or working. They are working as delivery drivers with Uber or food delivery, or working in takeaways or something like that. That is not a skilled occupation. Remember that. Yeah, I know Home Office doesn't get to it, but then if it is found, then you are in breach of your compliances. It's like everything else in life. So you you do these things, and once you are caught, yeah, it has a bigger impact. Then you are in breach of compliances of your visa, skilled worker permission. So that is it. And what else? Other things to talk about. Yes, one common question I always get on the skilled worker ILRs. I have a low battery, 10% left. Yeah, maybe by the time I reach home it will be to go to zero. So skilled worker ILRs, that absence letter, many people have asked me that. I've made several other videos, but it comes back again and again. You don't require the absence confirmation letter from any employer throughout the 5-year period. So when you're applying for a skilled work ILR on the basis of indefinite leave to remain, on the basis of being on skilled worker or a tier 2 general plus skilled worker for 5 years, then you don't need that absence letter. I know that application form will still show that you do need that, but it has been taken out from the immigration rules. If you can't get that absence letter from your previous employer, current employer, whatever that is, it is fine. Without that, the application will be approved. I have done many applications. The rules have changed quite long back, almost 2 years now, but still, yeah, the rules have changed, but still now, on the form, on the document checklist, it still shows up. That's what I've seen. Home Office said that has told us that they will change it when they come to it. I think it's a software expense for them to make any changes on the form, etc. So they may change it in future. But yes, if you are stuck in a situation where you are applying for ILR on a skilled worker visa and you don't have the absence letter from your current employer, from any previous employers, don't need to worry about it. You can file it through lawyers. We can explain reference to immigration rules and all. I've done it many times. So that absence letter is not required. One very important letter that is required is from your current employer, stating that you are still required for the employment in question for the foreseeable future. That foreseeable future is very important. Without that, the application will be refused. I know yesterday also I was looking at it and I told the client to put, we need that statement. You are required for this employment for the foreseeable future. So that is a very important point in the employer's letter at the point of indefinite leave to remain. And they also put the job code, salary, the salaries at or above the appropriate rate, etc. That's about skilled worker ILR. You need the latest payslip, latest bank statement. No previous payslips are required. Yeah, just with one latest payslip, we filed all applications and it is fine. And that is about skilled worker ILRs. And BRPs, I have I think 3 minutes to reach home. So BRPs, no more BRPs will be issued, whether you lost it, doesn't matter whatever your case is. BRP production has been stopped by Home Office. Everyone will get an e-visa. Any application you make, you will get an e-visa only, whether it is outside UK, inside UK. So no BRPs, you will not see any new BRPs being issued to anyone, because the production, the factory itself is stopped. They have stopped the whole production, whether you lost your BRP or anything like that. So that is about BRPs mainly. People keep on asking on the channel different BRP scenarios, and they are asking how to get another BRP. No BRPs, very simple, straightforward. And that is my answer. That is the Home Office answer also. They've stopped producing, I think, lost BRPs reapplications around 1st of October, and all new BRPs applications have been stopped now. So no more BRPs for anyone, only e-visa. I discussed more about e-visa in the previous live this morning. You can watch that video. Issues, passports, etc. Thank you very much for joining this live. Bye.